Hello everyone. As you know, immigration news changes almost daily, and these updates can impact your case, your family, or even your long-term future in the United States. I've recently attended 2 immigration lawyers conferences where we talked about recent immigration developments and how we can strategize our cases according to new trends. There are so many updates that we will bring you these updates in 2 separate videos. So there will be a part 1 and part 2. So today I will break down all the latest developments, including work permit changes, new fees, visa delays, and more. My name is Remzi Kulen. I've been practicing immigration law for more than 20 years. I know how confusing and stressful these updates can be, so I'm here to guide you through them. Let's start with the EADs. USCIS recently announced that the automatic extension for EADs for work authorization documents ended. What does that really mean? Starting October 30, 2025, people who file for a work permit renewal will not receive an automatic extension while the application is pending. There are some exceptions, such as temporary protected status or categories specifically protected by law or Federal Register notice, and F1 OPT is one of them. What this really means is applicants will face extra screening and vetting before USCIS extends any work authorization. USCIS recommended filing renewals up to 180 days before the expiration date to avoid losing work eligibility. This rule does not affect extensions already granted before October 30th, but anyone filing after that must plan ahead. What does this mean? Will USCIS expedite EAD applications so that nobody loses their jobs? I don't think so. The reason why automatic EAD extensions were authorized in the first place was because USCIS was not able to process these cases properly, and people would lose their jobs while waiting for an EAD extension. USCIS backtracks from this and goes back to square one, asking everybody to file their EAD extensions and hope that the EAD extensions will be approved by USCIS before their EAD expires. I don't think this is going to happen. I think what's going to happen is a lot of applicants will face with losing their jobs. This will be very stressful. Okay, then what can you do? You can file 180 days before the expiration date of the EAD. This is USCIS recommendation. In the past, some people filed even before the 180-day mark, let's say 210 days before or 250 days before, and their extensions were usually approved. This doesn't mean that USCIS cannot deny your application only because you didn't file within the last 180 days. So therefore, if you're filing earlier than 180 days, you're taking a risk of getting your application denied. But if you're filing within the last 180 days, you are risking not being able to get your EAD authorization approved on time and probably losing your job. So this will be a very big dilemma, whether to file before the 180-day period or after the 180-day period. We will share our experiences as we go along. As we were preparing this video to be posted on our YouTube channel, there was a recent development, and Trump announced that he's suspending the DV lottery program. There's a lot of confusion as to what this means. First of all, this is not a cancellation. Trump cannot cancel DV lottery by himself. What is a suspension? Suspension means they're going to pause the decisions on the DV lottery applications. It doesn't mean that you cannot apply. For example, if you want to file a 485 application in the United States, you can still do that. They don't oppose that. They're not going to accept the applications. They're just saying that they will probably not issue decisions on these applications. It is not clear what they're saying, but this is probably what it means, because they cannot stop people from filing. And the important thing is DHS secretary announced this via Twitter, so only DHS seems to be aware of this, but most of the DV lottery visa applications are being handled by Department of State at the consulates. We haven't heard anything from them yet, but as you know, this develops very quickly. Let's talk about the H-1Bs a little bit, because USCIS issued guidance, $100,000 H-1B fee, and clarified how the new $100,000 H-1B fee works under the presidential proclamation. The administration came up with several explanations, but this is what we know. The fee will apply only to new H-1B petitions for workers outside of the United States who require a visa to enter the US. So what this really targets is new H-1B applicants who will get their H-1Bs from the consulate for the first time. It doesn't seem to apply to people who have H-1Bs before, even if they go to the consulate to get a new visa, it looks like they will not be affected. It also doesn't apply to beneficiaries who are already in the US and are filing a change of status to H-1B application. A classical example would be a student in the US in a fund status or on OPT or on STEM OPT filing to change status to an H-1B. Now, if you choose consular notification, you will be subject to the fee, but if you choose a change of status application to H-1B, you will not be subject to the $100,000 fee. So I think in the new term, a lot of strategy will turn on whether someone can file a change of status application to H-1B in the United States. When it's a quota subject petition, it is difficult to do for a tourist, for example, but it will be easier to do for an F1 student. So what is important in this scenario will be maintaining your F1 status. You have to go to school, you have to have good grades, you should not go to school, and especially if you are on an OPT or CPT, you should make sure that you comply with all the terms and requirements and you document everything properly. Because my guess is that USCIS will start questioning a lot of change of status applications, because if your change of status gets denied, you have to go to the consulate to get your visa, which will trigger the $100,000 fee. But if your H-1B is approved as a change of status application, you will not be subject to the fee. So therefore, make sure you maintain your F1 status or any other status that you have before switching to H-1B, and make sure you document it properly. This fee also doesn't apply to H-1B extensions, amendments, or transfers for individuals already inside the US. So when does this $100,000 fee payable? Employers must pay the full $100,000 fee at the time of the filing, or the petition will either be RFE'd, they will send a request for evidence to ask for the $100,000 fee. USCIS also warned employers to expect increased Department of Labor review of prevailing wages and more scrutiny of job duties and skill level. There is also the weighted salary, which we think Department of Labor is working on. Weighted salary means in the H-1B quota application, higher salaries will have a more likelihood of being selected among the visa applicants. So we know there are 4 wage levels in the H-1B applications, and if you select a level 4 wage, you will be more likely to be selected than a level 3 or a level 2 or a level 1 wage. Now this will increase the chances of selection for entry-level applicants, and it will increase the chances of people who have higher experience and higher salaries while applying for H-1B applications. When you look at the big picture, it looks like it will be a messy lottery season for the H-1B applications. Some litigation is already going on the $100,000 fee, and we are expecting litigation on the weighted salary regulation, but I think there will be more litigation close to the lottery season, because then you can show immediate harm and you can ask for an injunction from the courts. What we advise employers right now is try to put in your application in the lottery, because just putting the application in the lottery does not mean that you need to pay the $100,000 fee. It is only if it's selected. Moreover, the $100,000 fee and the weighted salary can drop right before the quota season or even after it. And if you don't submit an application for the H-1B application, you would be out of the game. So make sure you submit your H-1B quota application until the dust clears. Let's talk a little bit about the family applications. USCIS updated its guidance on spousal petitions. USCIS clarified what counts valid spousal relationship for immigration. This update also explains how officers should evaluate marriages, including marriages performed virtually, marriages involving minors, and marriages from jurisdictions with different legal rules. Couples must still prove the marriage was entered in good faith, not for immigration purposes. In the last few months, it is our experience, and many other immigration lawyers' experience as well, that the marriage cases are getting interviews faster and they are being decided faster. So it's an interesting development, really. In the prior administration, it took months and months to expect a marriage card interview, and sometimes they waived the marriage interview and you would get your green card within, let's say, 6 to 12 months. With this administration, the marriage cases are being processed faster, 2 to 4 months, but almost every marriage case is scheduled for an interview. So it is interesting to see among all of these different things happening in immigration, the marriage cases are being adjudicated with an interview and even faster than before. One more thing to add on the marriage cases, that filing an I-130 does not protect someone from removal if they are otherwise removable. What this really means is if you have no status in the US, You need to be very careful while submitting that marriage application. You need to make a very careful strategy so that filing an application does not put you in danger. Maybe you saw this in the news, but there was an arrest in a San Diego marriage case where a spouse was arrested during a 485 interview because he was out of status. Now, this incident seems to be very specific to San Diego, and it never happened afterwards. And it is important to note that ICE has daily quotas to arrest people, and maybe this was one of those cases. But if you file an I-130 and if you're out of status, that may trigger ICE coming after you. So you need to be really careful about when to file the 485 and how you need to be prepared for the interview. Now let's talk a little bit about the Gold Card Immigrant Visa Program. This program creates a new pathway for foreign nationals who make a significant financial gift to the United States government. It's $1 million for an individual and $2 million from corporations donating on behalf of an individual. These contributions may count as evidence of eligibility under EB1, EB2, or NIW categories. As we were preparing this video to go online on our YouTube channel, there was a recent development on the Trump Gold Card. The Trump Gold Card website went online, and at the same time USCIS announced that they have a new form for this application called I-140G, and the G stands for the Gold Card. What do we know right now? You go to the website, you fill out the form, and once you fill out the form you get a confirmation. With that confirmation you can then go to USCIS's website and fill in the form. And in order to get this confirmation, you need to pay the processing fee. The processing fee is $15,000 per person. So there is not a lot of information on the website that you need to fill out, and there's not a lot of information that USCIS is asking in the I-140G form, which makes it sound like as long as the source of income that you are contributing to the United States, which is $1 million, is verifiable and you can prove the sources, it looks like they're not going to ask much information. We think that you would then be qualified under EB1 or EB2 by just giving this gift to the United States government, and once the I-140 is approved, you will then wait for either 485 or consular processing. How the processing is going to continue is such a mystery right now, and we don't know how USCIS will handle this or the consulates. All we know is the website is active. You can donate the money, you can pay the application fees, and you can file an application with the USCIS. Our word of caution would be to take it slow and see how this goes, because we think that there's going to be a lot of litigation about this. And even if you have the I-140 approved, you will still need to wait for visa availability in your EB1 or EB2 category, depending on your nationality. So please stay tuned for further developments. So thank you for watching today's update. I hope this breakdown helped you understand the latest immigration changes and how they may affect you or your loved ones. If you found this video helpful, please make sure to like, subscribe, and share it with anyone who might benefit from this information. I'll continue bringing you clear and timely updates, so stay tuned for the next video. If you have any questions, write it in the comments section and I will try to respond as fast as I can.